During a trial in a civil lawsuit, is it ever acceptable for me to jump up out of my seat and make an objection during the defense's opening arguments? You want to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. Is it ever acceptable to jump up out of my seat when my adversary, the defendant, is making opening arguments? Well, there may be instances where I feel that it's absolutely necessary to do that. There's no technical prohibition that says, hey, Oginski, you can't do that. Under no circumstance can you make an objection during your opponent's opening arguments. Traditionally, we tend not to do it. My adversary will tend not to make an objection during my opening arguments. Likewise, I try not to do it when they are making their opening arguments. It's an opportunity for each side to explain to the jury what they believe the proof is going to show in the case. The jury's paying rapt attention. And now, once you get those interruptions, it's going to distract the jury. It's going to distract the attorney. And now the judge has to make an immediate ruling. So there's no technical prohibition that says, hey, an attorney, you cannot object when another lawyer is making their opening arguments. However, there are certain instances where my opponent is going to say something or does say something that I feel is so prejudicial, that I feel is so inappropriate, that I have no choice but to stand up, yell out, objection, judge! And now I have to wait for the judge to rule on my objection. Is he going to allow the attorney to go ahead and say that? Or is he going to say, counsel, you can't say that, move on? Now, he may turn around and say, Mr. Oginski, that's what he claims the proof will show. The jury will ultimately decide whether or not what he's saying is true. So that is often what will occur if an attorney makes an objection during opening remarks. Because we want to let the jury know what this case is about. We want to let the jury know what the proof is going to show, what the witnesses are going to say as they come in to testify. And you will find that many attorneys actually make promises to the jury about what the evidence is going to show. So now at the end of the case, when they come back and make closing remarks, they can say, ladies and gentlemen, I promised you at the beginning of the case we were going to show A, B, and C. And in fact, this is what we've shown, and here's why we're entitled to a verdict. So to answer the question, is it ever appropriate for an attorney to jump up during opening arguments and yell out, objection? The answer is maybe yes and maybe no. So why do I share this intriguing story with you? I share it with you just to give you an insight of what goes on in these civil lawsuits involving accident cases and medical malpractice cases and even wrongful death cases here in New York. You know, I recognize and I acknowledge you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.